Why does he get to he shut me down when I was filming once already, and then he did torture and hotbox me. If you look at the video, it's clear. That's why the people are mad.
It is not every day that police officers are held accountable for their actions, but the courtroom often brings that reality to light. Today we will look at cases where reckless and arrogant officers were exposed and served a dose of karma in court. The first case follows after First Amendment auditor Drew Rebar was illegally arrested and hotboxed in the police car by Deputy Bueno. 2 years later, the deputy requested a protective order claiming that the public has been criticizing him ever since he uploaded the video of the incident on his YouTube channel.
During the course of that investigation, Mr. Rebar was arrested. That arrest was reviewed for probable cause by Justice Court judges, and Mr. Rebar pled no contest on 6/20 of 23. The deal being for Mr. Rebar to not enter the prison complex for a period of 6 months, at which time they would agree to a deal and dismiss the case against him because it wasn't a violent.
So that was the term of the plea negotiation?
Yes, sir.
Okay.
I do have a video, a record of that, as well as my understanding that the clerk can reference those videos if you need them, sir. Specifically on 6/20 of 23, when Mr. Rebar pled no contest without duress to these charges.
Later, Drew accepted a plea agreement, resulting in the dismissal of the case against him. Watch as Deputy Bueno, despite violating the law, tries to portray himself as the victim.
He made a complaint to the sheriff's office that he was tortured during this arrest. That investigation concluded that there was no such evidence and no such torture, period. And Mr. Rebar was adequately notified of that. Since the time that the charges were dismissed, Mr. Rebar has continued to fabricate that this was a false arrest. The court is very well aware of the no contest pleadings and how that works. But since then, he has gone online to no less than 10 different YouTube videos as well as on social media, and has deliberately lied and defamed and edited videos that he has posted, claiming that he was tortured, which was fully investigated, and claiming that he was falsely arrested, which is not true under his no contest pleading.
Deputy Bueno had mistreated a citizen and now wasn't able to take the hate that was directed towards him from other people on the internet. Well, that is how your life should be as a bad cop.
He deliberately distorts the facts in order to drum up financial and social support for himself and his cause. Since that time, false statements that he continues to make, I don't care about his personal vile comments towards myself, but this has turned into a frenzy that has endangered my 9 and 11-year-old children. I've received multiple phone calls from individuals stating that they know my children's names, where they go to school, and where we live. Mr. Rebar continues with these untrue statements that have endangered my family. My family has been called as well, and also threatened.
Targeting Bueno's family and threatening his kids is extremely wrong, but the auditor was not responsible for those actions and should not be held accountable for the behavior of others.
I have all the dates and times of when Mr. Rebar was arraigned, when he pled guilty. All the video, including the body camera video that I had on during the entire time, that showed his window down during the first 16 minutes that he was in the vehicle, as well as the air conditioning being fully on during the roughly 12-minute transport to the sheriff's office. Mr. Rebar made no complaint to me, period, of ever being hot or uncomfortable in the vehicle. Despite these facts that are clearly recorded on video, my family is in danger. Based on his statements, misleading, the comments continue to pour in via his channel and unchecked. And I'm asking the court today, based on the facts of this case that are well documented, to please help protect my children.
The insecure officer seems to forget that he works for the public, and it is bizarre to see how he's wanting a restraining order. Moreover, any comment made by the public perfectly falls under the First Amendment.
So I think in your application you talk about a couple of telephone calls to yourself and to your mother-in-law,
Yes, sir.
ex-mother-in-law.
Yes, sir.
And do you maintain that Mr. Rebar made those calls or somebody else, or do you know?
I don't think it was Mr. Rebar. I think it was in line with his commentary on social media and YouTube platforms that has clearly released my information, encouraged people to contact me, and by him deliberately distorting and lying about every aspect of this case, those comments and those people that follow him have a very vile and vicious way of trying to attack without even knowing the facts themselves. And again, Mr. Rebar is fully aware of every fact of this case and yet continues to deliberately distort them to fit his narrative.
After hearing his remarks, the judge approached Mr. Rebar. The auditor firmly asserted his rights and decisively challenged the officer who hates accountability.
Mr. Rebar, your comments. Why don't you think I should issue this restraining order?
My actions don't meet the black and the white of the statutes. My actions are protected under Article 1, Section 9 of the Nevada Constitution. My actions are protected under the First Amendment of the United States of America. My actions are only capturing images and disseminating them to the public. There have been several accusations made against me here that are just in fact untruthful. The only thing that I'm out there doing, Your Honor, is I believe we have a corrupt government.
The auditor goes on to explain his reasons for becoming one and emphasizes the importance of holding law enforcement accountable.
I just posted a video about our DMV yesterday. Our DMV is seizing papers from customers that have bought vehicles and having law enforcement hold them for 8 months while they investigate, and not issuing titles to people and giving people their property, Article 1, Section 1 of the Nevada Constitution. You and I, Deputy Bueno, everybody in this room has a constitutional right to property, yet our DMV is withholding titles for some bogus investigations they're doing. So I got off my butt, stopped running my business the way that I had for decades. Hooked up my camera, it's not on right now. And I was out on a public roadway, in a public parking lot, at a law enforcement facility.
The dishonest and cowardly officer was about to be exposed as the auditor prepared to reveal the truth behind the incident and the arrest.
You can go film law enforcement activities. The legislature is very specific in their language, and the governor signed it. And then you go out there and you're trying to have a conversation with somebody because you're in their parking lot and walking down a public roadway. And then you're arrested supposedly because you wore a blue shirt and you were trespassed. Now, Deputy Bueno goes into the fact that I entered a plea agreement. Now, I had representation. And what my attorney told me, Mr. Richard Salvatore, and I did talk to him a little bit about this. I spent about 30 minutes on the phone with him. He looked at my response, and he just didn't have enough time to help out. You know how you attorneys are. His schedule was a little bit full, and he thought I could probably do okay. But Deputy Bueno arrives, and within 40 seconds of him opening his door, he had me in handcuffs. How do you do an investigation in 40 seconds?
Deputy Bueno had arrested him for filming in a public place and then wanted to have no consequences for his actions. Worse still, the illegal arrest wasn't the only misconduct he committed.
The fact of the case is, yes, I did enter a plea agreement with my attorney's advice. And what my attorney's advice is, dismissed is dismissed is dismissed. However you got to dismissed does not matter. And I said, okay. And he goes, if you want to go to trial with this, probably going to be $20,000 to $30,000. So my decision was, do I give up my rights for 6 months or do I go out of pocket 20 or 30,000 to prove a point that gets the same end result? So my law, and I did put this on the record when I did take the plea agreement, that it was a quid pro quo specifically for this. And then I look at the United States Supreme Court decision under Thompson versus Clark.
The auditor was highly articulate and did an impressive job exposing the corrupt officer, clearly reminding him of his violations of the law.
We're there to be judged. We live in a society now where, like the press was many hundreds of years ago, and the church was trying to quash the press. We live in a society now where I'm sure you got one or two of these in your pocket, sir. I'm sure everybody in this room does, and if we see something funny, we probably whip it out and record it. Seems to be how our society is. Or everywhere we go, in this room, how many cameras are there? Throughout the sheriff's office, how many cameras do they have? On our street corners, do we have cameras? We've got cameras everywhere. The government controls most of them. I'm just one guy with one camera. And I publish what I see out there about our government. And I'm critical of our government. I'm critical of Deputy Bueno. I believe his actions were incorrect and they were wrong. And I have filed a lawsuit. And I do appreciate our Nevada Supreme Court in their ruling of Mack versus Williams, because that gives me an opportunity to bring it into the state courts. Because what my goal is, go on to my channel again and look, my goal is to bring some change to our system.
It is great to see Drew critically challenge the government and the police, holding them fully accountable. Watch as he ends his statement on a powerful note, completely dismantling the clown cop.
And if we can't petition our government, if we can't have freedom of press, and we can't speak what we believe is truth and be held accountable, if Deputy Bueno believes my speech is libelous, sue me for libel. Don't try to get a restraining order against me. This is further fear. Deputy Bueno in the first hearing the other day even insinuated that there were criminal charges telling a story to the public for them to disseminate and hopefully vote about and make change to our system. This is America. This is what this is about. It's not shutting me down. Why does he get to shut? He shut me down when I was filming once already, and then he did torture and hotbox me. If you look at the video, it's clear. That's why the people are mad, because my face before he put me in and my face when he brought me out in the booking room, and I was very clear with him in the booking room, I said, you hotboxed me. He took his camera off, faced it at me, and I clearly remember, you hotboxed me. Go look at the sweat dripping off my face, sweat dribbled right here. He even commented on how wet I was. It's all in the video. He says that there are video cameras of him opening vents and the air conditioning was on low. His testimony was low air conditioning. 95, have you ever been back in one of those cages?
The corrupt officer was given another chance to speak in court, but his remarks only further exposed his cowardice and lack of integrity.
Mr. Rebar has a case, a personal vendetta that he is out. His YouTube page is full of verbal altercations with anybody that he can strike up. On September 28th of 2022, he went to the prison to demand some type of paperwork, at which point he filed a false report of battery against the deputy director, which was investigated.
Objection. There's a lawsuit.
Excuse me.
What's the basis of your
Anything that you had to say?
There's currently a lawsuit against Deputy
Wait,
Quenga.
just a second, just a second.
There's currently a lawsuit against Deputy Quenga. I did not drop it.
All right, well,
There's a lawsuit upstairs against him. Mac.
The judge ultimately took some time to deliver the final decision, noting that it was a fairly unique case.
I'm going to take it under submission because I want to look at some things before I do make a decision. It's a unique case in that it's not directed at a specific person who made specific statements that endangered your family. It's statements by somebody that would cause somebody else to make a statement.
Yes, sir.
So it's a little unusual in that facet of it. But I'll make a decision. If I do grant the restraining order, protective order, it will be in effect for 45 days. At the end of that 45 days, you'll be subject to another hearing on whether it should be extended or not.
As expected, the judge denied Deputy Bueno's request for a restraining order against the auditor. The corrupt deputy likely realized that violating someone's rights and mistreating them comes with public backlash. While that officer was thoroughly exposed, the next one made such a serious blunder that he ended up receiving a lengthy sentence.
The drugs were there. I did not put the narcotics there.
This is Jackson County Deputy Zachary Wester, who is accused of planting drugs on innocent people. His trial eventually began when a total of 12 drivers reported that he had planted narcotics in their car and then arrested them. As a result, he was charged with 67 counts.
A substance that appears to be an illegal narcotic. Do you know anything about that?
I do not.
Have you ever seen this before?
No, what is that?
I'm just trying to figure out how that stuff got in your car. You're gonna go to jail today for possession of methamphetamine, okay?
Oh man, dude, I'm serious, dude. Anything, what you want me to do, man? I knew my truck was clean. I knew it was.
Anything in the vehicle I need to be concerned about? Hand grenades, launchers. Okay.
It's yogurt, sir.
I know. Okay.
It's yogurt.
How about this, though?
That is not mine. No, sir.
Okay.
Now, the white small plastic baggie that was in that spoon that the deputy just showed you on this video, had you ever seen that before?
No, sir.
Was that in your car?
No, sir.
Drugs were there. I did not put the narcotics there.
After hearing the victims' testimonies, the jury quickly reached a guilty verdict.
In the state of Florida versus Zachary Tyler Wester, case number 19-CF-431. We, the jury, find as follows as to the counts charged and the information. Count 1, guilty of racketeering as charged. Count 2, not guilty. Count 3, not guilty. Count 4, not guilty. Count 5, not guilty. Count 41, guilty of possession of controlled substance related to February 15, 2018, as charged. Count 42, not guilty. Count 43, not guilty. Count 44, guilty of possession of a controlled substance related to April 17, 2018, as charged. Count 65, guilty of false imprisonment related to Stephen Van, as charged. Count 66, not guilty. Count 67, not guilty.
All right, Mr. Clerk, if you'll go ahead and poll our jury. I want to thank you for your time and consideration of this case. I also wish to advise you of some very special privileges enjoyed by jurors. No juror can ever be required to talk about the discussions that occurred in your jury room.
The corrupt officer was found guilty of 19 of the 67 charges, and at the next hearing, the judge announced his sentence.
This court now sentences you as follows in this case. As to count 1, racketeering, which is a first-degree felony, you are sentenced to serve 5 years in the Florida Department of Corrections. As to count 7, official misconduct, as a third-degree felony, you are sentenced to serve 18 months in the Florida Department of Corrections. That will be served concurrent with count 1. As to count 9, official misconduct, a third-degree felony, false imprisonment, that's a third-degree felony, you are sentenced to serve 1 year and 1 day in the Florida Department of Corrections, consecutive to count 64. Counts 7, 9, 10, 31, 33, 34, 41, 44, 48, 64, and 65 are to be served consecutive to each other for a total sentence in this case of 12 years, 6 months, and 8 days in the Florida Department of Corrections. This sentence of 12 years, 6 months, and 8 days in the Florida Department of Corrections is to run concurrent with a 5-year Department of Corrections sentence in count 1. Therefore, it is the intention of the court that you are sentenced to serve a total of 12 years, 6 months, and 8 days in the Florida Department of Corrections. I'm also going to award the defendant 58 days jail credit as to count 1 and count 7, as count 7
Next, Wester was eventually sentenced assaulted an innocent individual and was later held accountable in his courtroom. While this officer was corrupt, the next deputy committed such a heinous act that it brought tears to the eyes of his colleague.
The detective said, "Side chick, that's his baby mama, and there's a possibility that the boy is his son." I'm thinking we're supposed to be the good guys. He's supposed to be watching my back.
It is rare to see a police officer held accountable for their crime, but today we bring you some of the most shocking cases of corrupt officers who did the unthinkable and faced justice in court. Starting with a Border Patrol agent who made the most shocking decision of his life. On April 9th, 2018, Laredo police officers and Border Patrol agents were notified about a double homicide that had occurred in a park. The suspect was another Border Patrol agent, Ronald Burgos Avias, who was in his car when the officer stopped him. It wasn't until 2023 that this case was on trial, and the first responders were telling what happened.
The person that was using that car at the time was supposed to meet a Border Patrol agent at the Father Magnoble Park.
Okay.
The transmission that came in was the boyfriend's name was Anthony Burgos.
Okay.
When the radio transmission came up for Anthony Burgos, there was only one Border Patrol agent that was at that location with us. I had just seen him. I had never seen this person before. I see him. He's right near the car, and so I wave him over. I say, "Hey, come here." As he's walking up to us, the name says Burgos. So we look at the name. I'm looking at the name as he's coming over, and I'm just like, "Hey, what?" I think this is the person they just called over the radio, but they said Anthony, and I look at the first name and it's an R.
Ronald Burgos had just committed the ultimate blunder, and he was about to be taken to the cleaners by his fellow Border Patrol agents who wouldn't fall for his bluff.
Tells him, "Hey, what's your name, man?" And he says, "Ronald Burgos." And we're looking for Anthony Burgos. And radio transmissions are coming through, and so it's kind of getting a little hectic. Burgos approaches closer to Reyes. I'm walking next to him. I'm the only uniformed officer. So I'm right next to him, and he says, "Hey man, what's your name?" And then Burgos says, "Ronald Burgos Aviles." He only uses his last names. So then Rick's like, "What's your name, dude? Why are you not telling me your name? What's your name?" And he says, "My name's Ronald Burgos Aviles." And he says, You're not telling me your name. Do you have an ID or something?" And he's like, "No, I don't have an ID."
The Border Patrol agent had just arrived after murdering his ex-girlfriend, the mother of his child Griselda Hernandez, and his 1-year-old baby Dominic Hernandez. It was appalling to see how Burgos reacted after doing something as heinous as this.
Yes, so once I took the belt off, I put it behind his unit, and then I patted him down as the unit approached us. So I patted him down. I located a phone on him and a driver's license in his shirt pocket.
Okay, so, and what did you do with those two items?
I turned over the driver's license to Detective Reyes, and the cell phone, I put it with his property that I had already taken, which was his Sam Brown. I put it in the back of his truck.
The prosecutor moved forward to show the court the dash cam video of the arrest of the Border Patrol agent. As you can see, the corrupt officer had no remorse on his face.
What is it that he's doing in that scene?
He's wiping his arms. Looks like he's cleaning something off, or
What was it that he did right before he wiped his arms?
he licked his finger.
Officer Ronald Burgos was desperately wiping his arms and even sucking his fingers, trying to remove any trace of evidence. He had just used a knife to his ex-girlfriend and their young son, with the evidence plainly visible to everyone.
on, man. Oh yeah, he could have just told me straight up, man, instead of making me go through it. Embarrassing, big ordeal.
As the trial progressed, witnesses came forward, and amongst them was a key witness, another Border Patrol agent, Francisco Lara, who made a shocking revelation.
I look south and I see the silhouette of the young woman. So I completely forget about Mr. Burgos and I start running towards the victim.
See the victim.
As soon as I see the victim, I approach and I start yelling. Like, señora, despierta, estás despierta. Ma'am, wake up. Because at this time, all I see is blood. I told my trainee, I call him Schmitty. I like, Schmitty, is that what I think I'm looking at? And I see the silhouette and I immediately start running towards her. And that's when I tell him, like, I start yelling at her, estás despierta, are you awake? Do you have any gloves? He's like, no, I do not. So I say, I don't have any gloves. And I asked my trainee, Schmitty, do you have any gloves? And thankfully, being the great agent that he was, he did have a pair of gloves.
Burgos had devised a strategy as moments after his ex-wife and son, he ended up calling the cops, claiming that a murder had been committed. Officer Lara explains how he tried to con everyone.
And I immediately check for a pulse. I don't feel a pulse. I look at my fingers and they're covered in blood because I checked her neck area. So I don't feel a pulse. So I immediately see her left wrist. It's facing up. I check her wrist and again I do not feel a pulse. Right away I told Mr. Burgos, sir, I think she's 10-7, which means that she's dead. And he's like, yeah, it looks that way. So I'm radioing everything into our station and I'm letting him know what I'm seeing. At this time he's standing there. Not really, the supervisor normally takes control of the situation and radios in everything to the station. Once again, he's quiet. I'm the one relaying everything that I'm seeing to the station. I'm processing everything in, I'm taking it in, and I'm telling them what I'm seeing. And right away, I start telling the camera operator to start scanning the river. I tell him, scan the river, see if you see anybody going back.
Burgos had used his police training to carry out the crime in a bushy area. Poor Griselda ended up having 27 stabs, and baby Dominic had received 2 as well.
Next to the victim, I check her. Mr. Burgos is standing over here I guess on the other side of her. So I tell him she's 10-7, which means she's dead. Radio everything in. I told base 2, I think she's dead. They tell me take a step back, trigger the crime scene. So before anything, I told my trainee, go to the gate and open it for the paramedics. He takes off. So before I take a step back, I'm surprised to see so much blood. So I grab my head and I'm like, where is all this blood coming from? I take a step back. At the time he picks her up, I could see the shadow of her face.
Officer Lara, a junior at the crime scene, could not believe his eyes as he watched his senior, Officer Burgos, handle the victim with shocking indifference and remained completely unfazed by the brutality of his action.
I get a phone call from my team leader. My team leader tells me, hey, we already activated the Border Patrol unions, the lawyers for you. Before you make any statements, we already got lawyers. And I'm like, we already made our official statement. He was surprised. He's like, oh, you did? I'm like, yes. He's like, before he hangs up, he's like, just so you know, there's a rumor saying that the dead woman is Burgos' side chick. I'm like, all right, 10-4, let me call you back.
It wasn't until detectives began investigating the murder that Officer Lara realized that the woman was Burgos' ex-girlfriend and the mother of his child. This revelation left him in a deeply emotional and shocked state.
We just heard her.
Go
go on a question and answer basis, Mr.
I'm good, sir. Thank you, Your Honor.
That is exactly how everyone in the court felt, and we can only imagine the condition of Griselda's family. It turned out Burgos had committed this horrible act just because he was refusing to pay child support. Finally, after listening to hours of testimonies and getting evidence, the jury reached a verdict.
In cause number 2018 CRA 852D1, in the case of the state of Texas versus Ronald Anthony Burgos Aviles, the jury has returned a unanimous verdict. I'm about to read the verdict of this jury on punishment as to count number 1. Special issue number 1 on count 1. Whether there is a probability that the defendant, Ronald Anthony Burgos Aviles, would commit criminal act of violence that would constitute a continuing threat to society. Answer, yes. Signed by the foreperson. Whether taking into consideration all the evidence, including the circumstances of the offense, the defendant's character and background, and the personal moral culpability of the defendant, there is a sufficient mitigating circumstance or circumstances to warrant that a sentence of life imprisonment without parole rather than a death sentence be imposed. Answer, yes. Signed by the foreperson of the jury.
The jury unanimously decided that Burgos would receive life imprisonment instead of the death penalty. Now, many might argue that the death sentence would have been a more fitting punishment for such a heinous crime.
You heard me announce the verdict of the jury with regard to both counts of this indictment. It is now my job to sentence you in accordance with that indictment, with that verdict. Do you understand that?
Yes, sir.
After being found guilty by this jury of 2 counts of capital murder, and after giving us the verdict that they have just announced, it is my job now to pronounce sentence. As to count 1 of capital murder, and as a result of the sentence of the verdict of the jury, you will be sentenced on count 1 as to capital murder to a term of life without the possibility of parole. As to count 2,
Burgos was immediately transferred to the jail and is guaranteed to die there. The shocking encounter truly left everyone speechless, and it is even more saddening that it took 5 years for justice to be delivered to the poor victim's family. Well, nothing might top the brutality shown by this officer, but this next tyrant made another huge mistake.
Nothing in his hands, and he was shot twice
in 2011, during a routine traffic stop, Officer Osvaldo Villarreal fatally shot an unarmed Benny Herrera. The victim's family filed a lawsuit, but it took 5 years for the case to reach pretrial, as Villarreal's attorney attempted to argue for qualified immunity.
It's a tragic case, there's no question about that. But Officer Villarreal was required to make a split-second life and death decision.
What required him to do that? It doesn't look to me as though he was the initiator.
The fact that Mr. Herrera, first of all, he had been acting erratically before the shots were fired, moved from a place of relative safety on the shoulder of the road into the roadway. He was skipping.
But if we're talking about Officer Villarreal, how much did he know about the prior behavior?
He saw all of that.
I have to say what you're saying is inconsistent with what I saw on his own camera. That is to say, the point at which he began to get close enough to see anything. Some of that earlier stuff was on the other camera, but not on his.
Officer Villarreal had shot the poor suspect only a second after he asked him to take his hands out of his pocket, and sadly, the attorney was defending this monster.
All at one point, his camera was turned on, but
his camera was turned on well before he got to the scene.
He testified in deposition that he saw Mr. Herrera on the side of the road, and then he saw.
Well, he can testify to what he wants to testify to, but I want to tell you what I saw on his own camera tells me that the early part of this he did not see, could not see. That was his intention, you say?
That was his intention, and that's in his deposition.
Again, I'm relying on what's on the videotape, and now this is in Officer Villarreal's car. I hear him say, "Take your hand out of your pocket," and I hear the gunshot almost simultaneously.
Exactly.
They cannot be separated by more than a second.
And that's exactly the time period when Officer Villarreal had to make his decision.
Shockingly, even the police department cleared Officer Villarreal's conduct, but the judge had another idea.
Here, Mr. Herrera was arguably complying with Officer Villarreal's order to remove his hand from his pocket at the time that he was shot. So how is it that we determine that we should grant qualified immunity?
Because qualified immunity allows for police officers to make mistakes. It allows for the possibility that officers will make mistakes in judgment, and that's exactly what happened here. Officer Villarreal had a choice to make. Do I wait and see whether there's something in the hand that could kill me, or do I shoot? And he made the decision to fire. We know, with the benefit of hindsight, obviously, that was wrong.
Is it safe?
The officer was about to face the consequences of his actions as the judge unanimously decided that his qualified immunity should be tossed.
As long as the historic facts are undisputed, the question of whether or not Officer Villarreal's actions were reasonable is a question of law. It's not a question that you give to a jury, because we don't want juries second-guessing the very, very difficult life and death decisions that officers have to make.
I agree, but at this stage, again, this is not an argument to a jury. For us to even have jurisdiction over this case, we take those facts. Yes. You're saying that as a matter of law, the shooting here was legal.
Yes, it was objectively reasonable. Well, not just those facts. Officer Villarreal knew that Mr. Herrera was a suspect in a domestic violence incident. Okay. He knew that he had a gang affiliation, that he was on parole, that he had a warrant out for his arrest. All of those things factor into
on parole. I don't remember on parole. They said
on parole, yes, and there was a warrant out for his arrest.
What do we know about what Officer Villarreal knew with respect to whether he was armed?
We know that dispatch told Officer Villarreal and Officer Miali that Mr. Herrera was not known to be armed.
The attorney continued to make bizarre and illogical arguments, but the judges swiftly rejected them, firmly believing that the officer should at least stand trial for his actions.
No, sir, the suspect had refused to put up his hands, had threatened the officers, and an officer believed that she saw something in the suspect's hand, saw him move his arm, and was worried he was going to shoot her. But yet we affirmed the denial of qualified immunity in part because the suspect had not brandished a weapon or spoken of a weapon.
I do recall that case, Your Honor.
The domestic violence incident was over.
Yes, and there...
So, I mean, how does that strengthen your case? I mean, that was, if you're arguing that it was an ongoing domestic violence, so...
It wasn't an ongoing domestic violence incident, but he was warrant out for his arrest, that he had known gang affiliations, and all of those things factor into, am I afraid of this encounter, or do I think that this is going to be a perfectly safe encounter? And everything that they observed, or a lot of the things that they observed, heightened the situation to a point where it was objectively reasonable for the officers. Nobody disputes that, for example, that it wasn't objectively reasonable for the officers to have their guns out. They were going to do a felony stop. Domestic violence under California law is a felony. So they had their guns out. There's some question about whether or not there were other alternatives available. Well, in the split second that decision had to be made, you couldn't put the gun down and pick up a baton. You couldn't put the gun down and pick up a taser, assuming that Officer Villarreal even had a taser. I think there's testimony in the record that he didn't have a taser available to him. He had to make a decision based solely on what he knew at the time. And it's easy for us to sit in hindsight and say, well, Mr. Herrera didn't have a gun. Mr. Herrera didn't really pose any
I don't think
threat.
anyone here said that one time.
No,
I think what we're focusing on, again, the narrow standard we have to deal with here. And that's what we're dealing with. This is not a jury trial. This is not summary judgment. It's a very limited thing. No one here is raised about the fact he didn't have a gun.
I understand. The trial court did.
The plaintiff's attorney stepped forward and presented compelling arguments that further solidified the need for the officer to face trial, strengthening the case against him.
And that the officers perceived a heavy object in that pocket. That's...
First part, yes. Second part, a little less clear. But I think there's no question that he had his hand in his pocket.
Well, and both officers said it looked like he had something heavy in his pocket. Okay. All right. And then just before Mr. Vial opened fire, Mr. Herrera rapidly removed his hand and moved quickly, it seemed like, toward the officer's car. Why isn't that enough?
Well, because sticking on the undisputed facts, the officers had no information that any weapon was involved in a crime. They were specifically told he was not known to carry weapons. He had nothing in his hands, and he was shot twice and killed. We specifically asked the officers about their training, and they conceded, which is included in the cites in our brief, that deadly force is a last resort, only to be used in the direst of circumstances, only when no other reasonable measures are available. And
finally, the judges reached a conclusion and gave one last shut-up call to the defense attorney.
If everything goes bad for your client, that is to say, if we send it back, if the jury says no qualified immunity, and if the jury comes in with an award of some amount of damages, will your client pay those damages out of his own pocket, or will it be paid by his employer?
It should be 99.9% of the times it's paid by the employer. I don't see why it would be different.
Well, by statute, California statute says it's paid by the employer unless they're punitives.
Yes,
isn't that right?
That was what I was going to say.
So that doesn't say 99%, it says 100.
Well, I was going to say, unless they're punitives. If there were punitive damages, the city would have the option of deciding whether to pay those punitives.
Next, this tyrant brutally assaulted an innocent individual and was later held accountable in the courtroom.
That was before the
Don't get brazen with me.
Courtrooms often mark the downfall of corrupt officers who believe they can act without accountability. Today, we'll explore cases where these officers were exposed and humbled in court. Stick around till the end. The last cop's actions will leave you speechless. Our first case is about the evil cop, Michael Amiot, who punched and kicked a person after pulling him over for a traffic stop. It didn't take long for the jury to reach its verdict.
We, the jury, being duly impaneled and sworn, do hereby find the defendant Michael Amiot guilty of assault, a misdemeanor of the first degree, in violation of Section 2903.13A of the Ohio Revised Code as charged in Count 2. We do so render our verdict this 29th day of July. Do hereby find the defendant Michael Amiot guilty of interfering with civil rights, a misdemeanor of the first degree, in violation of Section 2921.45A of the Ohio Revised Code as charged in Count 3. We do so render our verdict this 29th day of July, 2022.
The corrupt cop was found guilty on both counts. He sat there in silence, keeping a straight face, and clearly showed no remorse for his actions.
That is your decision as to whether you wish to speak with them. With that, anything prior to discharging the jury?
No, Your Honor.
On behalf of the defendant, anything? Yes. Well,
that wasn't the end of the trial, as the very next day, Amiot was called to sentencing. The victim was present and allowed to share a statement before the sentence was handed down.
I appreciate the jury and the court for making the right decision. You know, what Amiot did to me was wrong. He should have received the maximum sentences today. You know, I'm still going through like the suffering with the anxiety, you know, driving, just the temperament, the trauma and everything. This is a cause for this case. I'm ready to get it over it actually, but just coming back in here just like bring up everything, you know. Just to see him over there, you know, see all this, just coming back in this court, just like it just brings up everything, like you live at the moment. So, you know, I hope you get the maximum sentences today, you know.
Shortly after, Amiot was allowed to address the court, and he delivered a lengthy statement.
One of the most shocking examples was a prosecution witness called who testified that I was celebrating in the aftermath of this arrest. He testified that I was high-fiving, fist bumping, and dapping it up with other officers. There was 5 police cars on East 228th Street that day, all with their dash cameras on and rolling. They all had overlapping fields of view. I can be seen in front of one of those cameras the entire time I was on scene until I was transported to the hospital. Nothing remotely close to what the witness described happened with me or any other officer on the scene. They knew this and put the witness on the stand anyway.
The officer continued to offer explanations in an attempt to clear his conscience. Eventually, he took some accountability, but only to a minimal extent.
I take full responsibility that there was a failure on my behalf to get Mr. Hubbard in custody quickly. The incident was prolonged when I was shot with a taser. During the deployment, I broke my hand, ruptured tendons, and injured my shoulder. I want to end by saying I'm not an advocate for or against use of force. Everything I did on that day was based on my training and experience. From here on out, I'll be an advocate for subject control training department-wide going forward, so we can all be at our best when the time comes. I have a deep respect and love for the citizens and this community. I want to do my best to serve them.
Before announcing the sentence, the judge expressed his disdain for Amiot's action, aiming to make the officer feel the weight of his wrongdoing.
One of the things that stood out to me is that the initiation of this incident probably never should have occurred. When you receive that initial radio communication, that initiated this whole thing. And the other thing that sort of stood out to me was that in approaching the vehicle and asking Mr. Hubbard to get out of the vehicle, there was an inability for him to get out of that vehicle without making contact with you.
It is disheartening that Amiot never apologized to the victim, and the judge's personal comments must have been especially hard for him to hear.
I believe the jury got it right. I do. And the court must impose the sentence that the court feels is appropriate in a case like this. And I appreciate the city of Euclid compensated you. If you need assistance, you need to go and get that assistance. But I'm not going to say you're not going to have instances of flashback or what have you, but you need to move on with your life also. And not let this incident continue to hover over you. The city compensated you.
The judge also tried to tell the victim to get back to life and move on from this terrible incident. Finally, the sentence was announced for the tyrant cop.
The court at this time will impose a sentence of 90 days, require you to pay a fine of $1,000, and will require you to pay the court costs. In addition, the court will suspend the sentence of 90 days, place you on non-reporting community control for a period of 1 year. If you violate during that 1 year, then the court will retain the ability to impose the sentence. Anything on behalf of the state?
No, Your Honor.
On behalf of Ms. Amiot?
Just what count is this in for electing sentence?
What count, as opposed to the violation of civil rights? Not saying they weren't violated, but given the length of time, the court will use the assault charge. Anything else?
Judge Guy Reese sentenced Amiot to 90 days in prison and also fired him from the police force to ensure that such barbaric behavior would never happen again. While this judge was quite relaxed, this next one took this attorney to the cleaners.
And the court left the door open.
For me, not for you.
That was before the defense
Don't
testimony.
get brazen with me.
During the Kyle Rittenhouse homicide case, Assistant District Attorney Thomas Binger ignored the judge's previous rulings and continued questioning the banned topic. This led to a furious defense attorney and an even angrier judge.
I'm going to ask you to go into the library again for a moment, please. Please don't talk about the case.
He's either forgetting court's rulings or attempting to provoke a mistrial in this matter. He knows he can't go into this, and he's asking the questions. I asked the court to strongly admonish him, and the next time it happens, I'll be asking for a mistrial with prejudice. He's an
First of all, Your Honor, this was the subject of a motion. I'm well aware of that. And the court left the door open.
For me, not for you.
It was clear that Judge Schroeder was extremely angry at the prosecutor, as he dismissed the jury for a while to hold him accountable.
My understanding of
You should have come and asked for reconsideration. You did on the one motion, and in fact, I granted your motion for reconsideration.
That was not our motion.
Why would you think that that made it okay for you, without any advance notice, to bring this matter before the jury? I was astonished when you began your examination by commenting on the defendant's post-arrest silence. That's basic law. It's been basic law in this country for 40 years, 50 years. I have no idea why you would do something like that. And it gives, I'll leave it at that. So I don't know what you're up to.
The prosecutor had made a huge mistake, and things were about to get from bad to worse for the poor guy.
He was using it in a manner to try and protect property.
No, he wasn't.
Your Honor, with all due respect...
I'm not going to rehash the motion. That's absolutely untrue. No. Your arguments of record, my comments are of record, and why I ruled as I did is of record. There's nothing that I heard in this trial to suggest anything's changed, even if you're correct in your assumption that you know more than I did at the time. Why you would think that you could go into it without any advance notice to the court, I don't understand that. And as the defense is pointing out, you're an experienced trial lawyer, and this should not have been gone into.
The defense panel was growing restless, unable to believe what they were hearing. Binger's excuses were weak, and he was about to be called out for them.
The defendant has just testified this morning that he agreed with that person in the yellow pants, that he pointed the gun at him. He said, I was joking when I said that to the guy in the yellow pants, but he's acknowledged that he told the person in the yellow pants, yeah, you're right. I did point a gun at you when you were sitting on a car.
He said, I did. That's what he
Exactly.
testified. You know, there's a lot of difference between commenting about something when you haven't got a gun and threatening someone when you do.
You know, it's interesting, Your Honor, because the entire defense theory in this case is Joseph Rosenbaum, who was unarmed.
I want you to tell me what the defense theory of the case is. May I
respond to what you just said, Your Honor? I'd like to respond to what you just said. I apologize, Madam Court Reporter, but I'd like to try and make a record without...
Rare to see attorneys speak to police officers in this manner, and if Binger continues this behavior, he could be held in contempt of court.
On his beliefs and on his statements.
I'm going to interrupt you now because you're talking about his beliefs. I think that's what they call...
His statements do, Your Honor. Because he just said, can't use deadly force, can't threaten to use deadly force to protect property. So now I'm impeaching him on that.
Your Honor, the court has seen no reason to change its ruling, and just so this record is clear, in spite of the lengthy statement by Mr. Binger, before we started today, the court specifically stated in Mr. Binger's presence, there's been nothing to have me change any of my rulings. He knows if you're going to go into something that's been excluded in a pretrial order, you better ask the court, you better get permission. This is ridiculous.
It wasn't excluded, Your Honor.
You know why it was excluded in the first place? Because it was propensity evidence.
The judge taught him a lesson about who the boss was, and just when he tried to talk over him, he delivered one final blow.
His attitude is he wants to shoot people. Now, I've admitted that kind of evidence in other trials when it's been appropriate. I didn't admit it in this case because, to me, what I've heard in this trial, and by the way, Mr. Richards absolutely correctly points out that just hours ago, I said I had heard nothing in this trial to change any of my rulings. So why?
Testimony, Your Honor.
Pardon me?
That was before the defense
Don't
testimony.
get brazen with me. You knew very well. You know very well that an attorney can't go into these types of areas when the judge has already ruled without asking outside the presence of the jury to do so. So don't give me that. That's number one. Wigmore and evidence. Judge Weinstein, Colonel McCormick. It's the crime. The prior act has to bear the signature of the accused, or it has to be so similar as to suggest it's a common plan or something like that.
The judge delivered a brief speech to instill discipline in his courtroom before calling the jury back.
When you were I said you were over the line and close to or over the line on commenting on the defendant's pretrial silence, which is a well-known rule that would have been an issue. So I don't want to have another issue as long as this case continues. Is that clear?
It is.
Thank you. Ask the jury to come back in, please.
This was surely humiliating for the attorney, and he'll forever think that he should never have broken the rules. Coming back to police officers, here is another instance when a corrupt bully was questioned and owned.
Did you apprehend good guys?
Never. I take that back. I bit a victim one time because she jumped in front of me.
Daytona Beach police officer Joshua Mesereau was involved in a gun battle with Marvin Jones, who was shot 5 times. Jones also had his girlfriend with him, Aviana Bailey, who the officer also shot. The young mother-to-be was left paralyzed from the chest down after the incident. Following this life-altering event, she filed a lawsuit against the police and the city.
Playing, fumbling, doing something with in his lap. There's none of this. There's none of this. It's this. And he's looking at me the whole time. And then it happens.
What happened?
He sticks the gun out the window and points it at me.
Okay. How does he stick the gun out the window?
If I'm sitting in the driver's seat, where would my... So he just went just like that.
Okay.
And it was between the mirror and the A-post.
Okay.
Well, actually, if I'm driving...
Exactly.
I'm sorry. If I'm driving, the driver's side is... The door is here. So he did this.
Okay. Because you had him moving...
Excuse me.
...further into the passenger compartment.
No, that was completely...
Right.
That was my mix-up in the side. It was the right side that he did it with, and then he put the gun between the window.
Officer Joshua couldn't even get the story straight, and you'll be shocked to see how casually he took the deposition.
You said right side again.
Left side. I'm dyslexic.
Are you dyslexic?
No,
Okay.
I'm sorry. I didn't. That was a bad joke.
Do you recall how many rounds?
Just one at that time.
Okay. And where did it strike?
The hood and windshield area, right in front of him.
And how many muzzle flashes did you see in total at scene 2?
At least the initial, at least one, and possibly 2. I can't count them. I can't tell you how many exactly I saw.
The officer's demeanor clearly showed his ego, as he was taking everything just a little too lightly. It was clear he had no understanding of how drastically Bailey's life had been altered. She could no longer even care for her baby.
I was committed to engaging him, and I did that. At which point, my ankle rolled off the curb, and I fell on my back.
Okay.
I was falling and still shooting, so somehow the gun jammed from limp wristing it.
Okay. That were fired at you, or you saw several muzzle flashes?
Yes.
How do you define several?
Objective 1.
1 or 2? 2 probably.
Okay. Several's not 1.
Yeah.
We agree to that. Is several more than 2?
Objective 1.
I would say 2. So we'll say a couple.
Okay.
Investigators pressed Joshua about the tragic incident, but he continued to make light of this serious situation, attempting to joke instead of addressing it responsibly.
In your deposition, you discussed dust. Tell me about that. Was there dust at scene 2?
Yes.
Tell me about that.
There was dust at scene 2.
And I understand there may have been dust on the ground, but did the dust become airborne?
Yes, from the suspect's vehicle spinning in the grass, which was dry.
Did the dust settle? Let me say, before you got out of your car?
No.
Okay, so there was still some dust in the air.
Correct.
When did the dust settle?
Still hasn't settled. I guess it never really did. I mean, that I remember.
Okay. Now, before you got out of your car and engaged Marvin Jones, did you know anything about him or his background?
Just the fact that he might have some felony warrants out of New Hampshire.
How did you learn that?
Apparently, somebody called from New Hampshire to rat him out.
Joshua had no remorse for his action, and as the deposition continued, his answers were about to get even more weird.
What threat was posed to the safety of an officer or other person at the point you first got out of your car?
There was none.
Okay. What threat to an officer or other was posed when you first drew your firearm?
There was none.
What threat to an officer or other was posed when you got out of your car, when you took a step towards the Lincoln?
Objective one.
At this point, the defendant's actions.
Okay. Which were what?
Fumbling around on his, making very furtive movements.
Okay.
Kept looking at me.
The attorney then questioned Joshua about his troubled past, which included being removed from his role as a canine officer. When pressed on this matter, his cocky and dismissive responses were shocking.
Did you have your duties as a canine handler revoked or rescinded at any point?
Yes, I did.
What happened or why?
Form of objection.
In my opinion,
Yes.
I was doing my job too well.
What does that mean?
It means I was beating the streets and I was catching bad guys.
Okay.
There wasn't a lot of bad guys that got away from me.
Because your dog got him?
Because we got them as a team.
Okay.
And if you have an above average bite ratio, that means you could be using your dog too much.
Okay.
A bite ratio is how many people you apprehend and then how many people you dog bite during that apprehension. So they're saying 30%. So they're saying out of 10 people that you apprehend, you should bite 3 of them, let's say.
Okay.
Which never made any sense to me.
The officer was so arrogant that he had no clue that he was appearing stupid. His desperate attempt to portray himself in a positive light only highlighted his dangerous and bullying nature.
When was your canine handler duties taken away?
Late 2011. As a matter of fact, December 23rd, 2011.
Okay. Why does that date stick out?
Worst day of my life. I enjoyed the job. I would have paid the city to come do that job. Tracking down bad guys and finding them and apprehending them.
Did you apprehend good guys?
Never. I take that back. I bet a victim one time because she jumped in front of me. So I did. I bet a victim one time.
Was that another officer?
No, it was a victim, a domestic violence victim.
Joshua's history was riddled with poor decisions and excessive use of force. The attorney dug deeper, exposing his psychopathic nature.
Do you need supervisor authority to conduct a strip search?
Yes, sir.
Did you obtain supervisor authority before you searched Justin Riddle?
No, sir.
Did you receive counseling or did a supervisor talk to you about that and tell you did that portion incorrectly?
Yes, sir.
Okay. March 2011, there was a newspaper article about a lawyer that claimed you used excessive force. Do you recall that incident?
Yes, sir.
Tell me about that.
He was Yeah, Roe. He was hammered. He was drunk.
Oh yeah, I remember this one. This is the one where you were alleged to have gone in a home without permission, like moved somebody's arm. You recall that incident? What happened there?
I was on K9. We were looking for, they're twins. There's two of them. I forget their names, but we saw one on the bed through the window. And I'm like, that's him. That's him. But this is before I knew he had a twin or a brother. So he had a felony warrant.
The twin did?
No.
The one of them.
The one of them had a felony warrant.
The guilty one, not the
yes.
innocent one.
So the mother's there, and we got the place surrounded, and basically she said, you're not coming in. Well, he's in there. We can see him in there. We can force entry on a felony warrant if we see the person and we confirm it's him. I eat that one. That was my responsibility all day long for not knowing that it's the brother. But they do look different. If I had seen his face, maybe paid more attention to his haircut.
Did you ever arrest a good guy?
Did I ever arrest a good guy?
Yeah.
Not that I can recall.
So
eventually, the tyrant cop was saved by qualified immunity. But poor Bailey did receive some settlement money from the city. Now that won't be solving her problems, but it might give her something to cheer about. And that brings us to the end of this video. Today we witnessed corrupt cops being held accountable in court and some shocking courtroom moments. It is astounding how these officers act as if they are above the law, causing irreparable harm to innocent lives. However, these cases serve as a wake-up call for others in law enforcement to reflect, reform, and uphold their duty with integrity. If you agree with me, please support us by liking this video. Also, if you enjoyed this video, watch some more of these satisfying moments when officers were humbled in courtrooms.
Then I want you taking him up on perjury.
Your Honor.
Will you take him up for perjury?
He admitted it was a mistake, Your Honor.
No, but he lied. He lied on a sworn
Absolutely
citation.
not, Your Honor.